So you're buying or selling a house. Now what? Stick around. We're going to talk about it. Hey guys, so welcome to another episode of Suits and Boots Legal Talk. My name's Luke Martin. I'm one of the attorneys at Benbow, Davidson & Martin. And it's just me today, all alone, so I hope you guys don't mind hearing me talk a lot. But we're going to make it quick. We're going to go through some really interesting stuff today. We're going to talk about what happens when you're buying or selling a home. So in today's market, what normally happens is people have a real estate agent. Real estate agents make things so easy when you're going through this process, but they're not required. Typically what happens every time someone's buying or selling a home, and if you're selling, you've probably already talked to a real estate agent and said, hey, I want to list my house. Will you put it on the MLS and get me a buyer? So maybe that's the case. Maybe not. Maybe you drove a sign up out in the yard and said, hey, this house is for sale. Come buy it. Either way, this process almost always starts with a contract. So whether you've listed your home with a real estate agent or you've got it for sale by owner, someone has come and they've said, hey, we want to buy your house. What do we need to do? Well, the first thing we always recommend folks do, whether you have an agent or not, is get a contract. Most of the time with an agent, that agent will put the contract together for you. You probably won't need to talk to your attorney, but you may want the attorney to review what the agent puts together or may not. The agents around here that we work with all do an excellent job. So they'll put the contract together. The contract that most people use in North Carolina is a standard form contract that was developed by the North Carolina Real Estate Commission and the North Carolina Bar. So that contract is the same in almost every transaction. Look for other podcast episodes coming up where we're going to go through that contract line by line and tell you, here's what this section means, here's what this section means. That way, whenever you get to this point, you'll kind of have an idea of what to expect. So you got to sign that contract. Once you sign the contract, you've agreed on the price, you've agreed on all the terms that you want in there. Maybe there are some special terms that you've put in, and sometimes as attorneys, we draft those special terms to put into contracts, even when there are real estate agents involved. But either way, the next step, if you're the seller, is kind of anticlimactic. You just get to wait. Because now the buyer starts what's called the due diligence process, and there's not a whole lot for the seller to do. Now, maybe as a seller, you're looking for your replacement property if you're moving to another property. Maybe you're starting to move a few things. But early on in the process, you want to wait and see what happens during the due diligence period. The due diligence period is when the buyer has a chance to make and do all these inspections on the property. So they will have a home inspector come out. There'll probably be an appraiser come out. There'll be, if there's a well, there'll be a well or septic inspection, those type of inspections. All these things are done. And it's just a way for the buyer to come in and look at the property and have professionals look at the property and make sure, hey, is this the property we want to buy? Most of the contracts that we see will allow the buyer to walk away during that due diligence period with no penalty. So that means, seller, if you are expecting that as soon as they sign that contract, we're definitely going to closing, you might want to take a breath, because sometimes these contracts don't make it to closing, and sometimes the buyer can walk away without having to pay anything. But as a seller, you get to relist the property and sell it and find another buyer. So during that inspection period, or during that due diligence period, we're going to have the inspections, appraisals, those kind of things. Once the due diligence period is over, typically the next step is to move toward closing. Sometimes the buyer will ask the seller to make repairs of things that are found during that due diligence period. Sometimes not. Sometimes everything goes as smooth as can be, and we go straight into closing right after due diligence. Either way, every situation is going to be different. Your agent or your attorney will help you walk through that process. Now, as we move on to closing, the buyer's role in closing and the seller's role are two different things. And we're going to go over a couple of things that you're going to see in closing. A lot of this stuff you'll get a heads up on. It won't just be given to you the day of closing. Your real estate agent will talk to you about it. Your attorney will be sending it out to you in emails and things like that. One of the most important things during this whole process is communication. So you need to stay in touch with your real estate agent. You need to stay in touch with your attorney. If you're a seller and you've got an attorney, stay in touch with that attorney. Say, hey, what's going on? What do I need to do? What do you need from me? And your attorney will be in touch with you. So check your emails. So often our office will send out emails with information in it. And our client will call and say, hey, I don't know anything. You guys haven't talked to me about anything. And we've been sending emails after email after email. So always check your emails. That's the best way to contact us, and it's the best way for us to contact you because it gets you what you need in writing, and you can look at it, read over it, digest it, and then feel free to call us with questions about, hey, I got your email. What does this mean? And we can talk through that. But communication during this whole process from beginning to end is key. Communication with your real estate agents, communications with the attorney, communications with the other party. Stay in touch with each other and keep everybody on the same page. And that just makes everything go smoother. This is where real estate agents are really helpful because that's what they do is they coordinate this whole dance as we go from contract to closing, to make sure everything goes as smoothly as possible. Now, at closing, there's going to be different documents that you're going to see. And for the buyer and seller, those documents will be just a little bit different. One document that's going to be the same, though, well, it's going to look the same. They're going to have different fees and different things on there. It's called the settlement statement, or in some cases, the closing disclosure. So in a cash transaction, oftentimes it's just called a settlement statement. Where there's a lender involved, it'll be what's called a closing disclosure. Now, the closing disclosure is one of the most important documents that we have in the closing process because it lists out one of the most important things that we're going to talk about in the closing process, and that's the money. Everybody wants to see the money. So how much am I going to leave closing with is what the seller wants to know. The buyer wants to know, okay, how much am I going to have to bring to closing? Well, the settlement statement is what gives us that information. So the settlement statement goes through all of the fees, all of the things that might go into it, all the things that come out of the seller's proceeds, all of the things that go into what the buyer has to bring. So if you have questions about that, then call the attorney, talk to your real estate agent. We can go through that thing line by line, and we will, in closing, go through that settlement statement or closing disclosure line by line and talk about every little item on there. And if you have questions, ask those questions. Some people might think, well, I'm not going to ask that. That's a stupid question. Please don't think that because we do this every day. A lot of the things on these documents we'll just breeze over because it's something that we saw 2 times yesterday and the day before and the day before. You might only do this 1 or 2 times in your life, so make sure to ask questions. Make sure you understand every part of the process, and no one minds to answer those questions. That's what we're here for. So you'll see that settlement statement, whether you're a buyer or seller. As a seller, there'll be a few specific documents that you'll sign that the buyer won't have to sign. One of those is the deed. Probably the most important document in the closing process is the deed. If we don't have a deed, we don't have a closing. So the deed is what actually transfers title. Now, as a seller, you might be thinking, well, I've got my deed. I need to bring my deed to closing. And if you're thinking about car titles, that would be true. So with a vehicle in North Carolina, you have a title to that vehicle. And whenever you sell it, you pass that title on to the new owner. But in North Carolina, deeds don't work that way. So with a deed in North Carolina, your attorney or the closing attorney or the seller's attorney, if the seller has a separate attorney from the closing attorney, will prepare a new deed. That deed will convey the property from the seller to the buyer. There'll be things in there like the language is grantor. So the grantor is a fancy way to say that's the seller. That's the person that's conveying the property or giving the property. And then you'll have the grantee. The grantee is the buyer. They're the person that's getting the property. So that's the deed. The seller will sign that deed. Now, one important thing to remember about deeds. Sellers, if you're married and you don't have a prenuptial agreement, your spouse has to sign the deed. Your spouse has to sign the deed. That's something that folks get really confused about because, if that property was passed down from your mom or dad or something like that, and your spouse's name is nowhere on the deed or nowhere on any of the documentation, it's not in mom and dad's will, it's not anywhere else, why does my spouse have to sign? In North Carolina, the law is that spouses have to sign whenever you're selling property. There's a couple of exceptions to that. One would be if there's a free trader agreement, which says that spouses can deal independently from one another, and that's something a family law attorney can help you with. That's something our office can help you with. Or if we've got a separation agreement with a free trader agreement incorporated into that agreement, or if we've got a prenuptial agreement that happened before the parties were married, something that says, hey, my spouse can deal with his or her property on their own without my joinder. So that's the deed. Secondly, sellers, you're going to sign what's called a lien waiver or indemnity agreement. Whew, what a word. Indemnity agreement, owner affidavit, lien waiver, all these things are synonymous for the same document. And that document says that there hasn't been any work done on the property within the previous 120 days that hasn't been paid for. So if someone comes out to your property, say it's a plumber, and unstops the sink drain, that plumber gets what's called a mechanic's lien on the property for 120 days or until they're paid for the work they've done. So the concern is that lien that the plumber has isn't published anywhere. There's no way for the title insurance company, the title attorney, the closing attorney, the title searcher, there's no way for anyone to find that lien because it doesn't exist on paper. It's just a matter of law. That plumber gets a 120-day lien or until they're paid. Now, you as the seller are going to sign off on a piece of paper saying, there's not been any work done that hasn't been paid for. And if there has been any work done that hasn't been paid for, or there are any mechanics or materialman's liens, I agree to pay for those things. So if anything comes up, seller, you're going to say, hey, I got it. I'll take care of it. The other document that you're going to sign as a seller is called a 1099. Oh, yeah. The lovely 1099. Uncle Sam is always going to track where the money goes. He wants to know, okay, Mr. Martin, you had this $100,000 come into your trust account, and then it left your trust account. Where'd that go? Well, we've got to report that. Everybody that sits at the closing table says, do I really have to sign it? Yep, you got to sign it. Yep, I've got to report it. If I don't, I get in trouble. If you don't, you get in trouble. Let's just not do that because I don't think either one of us look good in orange. So we want to sign that 1099. That's going to be one of the documents. And then there's going to be some miscellaneous law firm forms. Now, every closing is going to have some different pieces to it. Sometimes there are easements conveyed. Sometimes there are shared driveway agreements. Sometimes there are well agreements. There's all kinds of potential documents that might come up in your particular closing. Almost every closing is different. So just don't be surprised if you see some other documents besides what we've covered here today. We're going to have some miscellaneous law firm forms. If you've got payoffs, if you owe money on the property that you're selling, then we will take care, as a closing attorney, we'll take care of making sure that loan gets paid off from your proceeds. We're going to have you sign some documents regarding that and how we handle that payoff. So there's going to be some other miscellaneous things that you'll see. Now, if you're the buyer, so you're buying the property, what documents should you expect to see sitting at the closing table? Just like we talked about earlier, you're going to see that settlement statement. Your settlement statement is going to have a lot of bank fees on there, a lot of the title search, those kind of things, those kind of fees on there. And we'll go through some of that here in just a little bit. But your settlement statement is going to look a little different than the seller's settlement statement or closing disclosure. But it's going to be essentially the same thing. It's going to break down all the funds, where they're going, how they're going to be used, and how much money you need to bring to closing. After that, if you have a lender, there's a lot of other documents that you're going to need to sign. If you don't have a lender and it's a cash deal, it's super simple for the buyer. You've got that settlement statement, and then you'll have just maybe a few law firm documents to sign, and you're done. That's it. Oh yeah, don't forget to bring the check because I'm going to need that, and so is the seller. But otherwise, that's it. That's all you need. Now, if you have a lender, there's going to be some documents that are going to be super important that you're going to sign. So typically I start with the settlement statement, which we've already talked about, and then we'll move into what's called the note. The note is, no, not a love note. It's a note that says, hey, bank, I promise to pay you back the loan amount, whatever that is that you've made to me. It's going to list that loan amount. It's going to list the interest rate. It's going to tell us whether that interest rate is fixed or variable. It's going to tell us about the length of the loan. Is it a 10-year loan, 15-year loan, 30-year loan, those kind of things. It's going to tell us when that first payment's due, when the last payment's due. One of the most important things that we always point out to people in closing is it's going to tell us, that note is going to tell us, is there a prepayment penalty? In residential, there's almost never a prepayment penalty. In commercial, sometimes there can be a prepayment penalty. It's all dependent on your type of loan. But in residential, where we're buying a house, almost never a prepayment penalty. So you can pay that thing off anytime. So if you've got a variable rate, or if you're right now refinancing or buying a home, you've probably got a higher rate than you would like to have. You can refinance that and get something smaller. One of the things that we've heard lenders say and real estate agents say as we've talked to them and done these podcasts is, hey, you date the rate, you marry the house. So the rate, you might change that at any time. The house is something that you're going to live in for a long, long time. So don't be too concerned about the rate. It's something that can change and will change, and you can always refinance. So get the house that you want, and we'll worry about the rate later. Now, so that's the note. The next document is going to be the deed of trust. The deed of trust is the beast. It is sometimes 20, 25 pages long, and it goes through so many dense details. One of the questions that I get asked at the closing table often is, you ever had anybody read all of this? And I tell you, I had a guy one time get 3 pages into the deed of trust. And I thought, man, if he's going to read this whole thing, I'm going to have to go do something else. But then he said, you know what, where do I sign? Because it's just so dense. My job as your attorney is to read over this stuff for you. I've read these documents over and over and over again. Fortunately, most of the documents that we see in closing are the same in every closing. So we read through them. We make sure that those documents are the same. If we see a document that's, that looks a little weird, I don't know if I've ever seen one of those, we check it out. We read it. Sometimes sitting at the closing table, I'll sit there and read a document in front of the clients and say, hey, here's what I think this document says. I think it's okay to sign. Here's why I think it's okay to sign. Here's what it means. Every document we go through, and this is especially true on the buyer side, every document we go through, I'm going to give you a summary of what this document is. I'm going to hand it to you and say, I'm not going to read it to you because goodness, nobody wants to sit through that. But we're going to say, hey, this is the note, and just like I just did with you guys on the podcast here, this is what the note says, this is what it means, this is what it does. This is the deed of trust. So that deed of trust is what's recorded at the Register of Deeds. This is what gives the bank a lien on the property. It gives them security to make sure they get paid. And how does it do that? Well, some people will tell you, if you don't pay, you don't stay. So that's what the deed of trust says. If you don't make your payment, if you otherwise default on the loan, then the bank can come in and foreclose on the property so they can get paid. They'll either sell it to get paid, or they'll always sell it, and then sometimes they're the buyer, sometimes they'll buy it. I know that there are some banks who hold these properties and will even use them as rental properties. Sometimes you see them at the courthouse and you'll see a foreclosure sale and they'll relist them with a realtor. Either way, you would lose the property if you default on the loan. That's what the deed of trust says. It says things like you got to keep insurance on the property. You can't conduct illegal operations on the property. Sometimes it'll say the property has to be your primary residence for so long. All these things go into the deed of trust, and every deed of trust is a little bit different, and we read through those so that you don't have to. Our job as your attorney is to know the documents that you're signing, explain those to you, give you a heads up, and let you know of any problems that we may see. Almost always, these documents are the same, and we rarely ever have any problems with any of them. So the other documents that you're going to see as the buyer are going to be bank forms. So if you've ever been a buyer in a closing for real property where you've got a loan, you know that the closing package can be really, really, really thick. There's documents in there that will say things like, this is your primary residence. And I had a lender one time who had that form in there that said, you're buying this as a primary residence. This is not a second home or a vacation property. And they would have that same document in the closing package 5 different times. And you think, I've already said this. Yep, you have, but we got to sign it again. I don't know why the lenders do that. So often people ask me, hey, I've already signed this. And oftentimes at closing, you'll sign things that you signed for the lender long before closing, but you sign them again at closing. One of the most common things is the application for the loan. You always sign that again at closing, even though you've already signed it before. There's all kinds of reasons for that, all kinds of compliance reasons that the lenders have for doing that. It's just a lot. So when you get ready to come with a closing where you're using a lender, just make sure and do your hand exercises the night before. Be ready to sign because you're going to sign a lot. But we'll get through it. And we'll go through every document. And usually it takes about 30 minutes, maybe 45 minutes to go through one of those, and we'll be done. And then you'll be a homeowner. So it's terrible for the first, for that 30 minutes, but I try to keep it light. We try to have fun. And it's good to sit and talk with you guys. So the other things, you'll have just a few law firm forms, just like we talked about before, some miscellaneous things that may come up. Now, some fees that you guys might see as sellers and buyers before we leave today. So the seller fees are going to be, and these things are fairly universal throughout the state of North Carolina. This is what almost all the contracts will say, and the form contract kind of lays this out as the default. Now, you guys can change these as you see fit as buyer and seller, so these are negotiable. Almost everything in the real estate process is negotiable. So if there's something that you want to do differently than what the standard would be, just talk to your agent about it, talk to your attorney about it. We can usually work things out as long as the parties agree. So some fees that you may see, if you're the seller, here are some things that you're going to see. The first thing will be agreed upon seller credits. So these are going to be things that you agreed in the contract or any contract amendments that you say, hey, we're going to contribute this much money. Maybe it's $1,000, maybe it's $10,000 toward buyer closing costs. So we're going to help you pay your closing costs, buyer. We're going to contribute this amount of money. Sellers will often do this in order to entice buyers to pay a higher price or to entice buyers just to come and say, hey, buy my property. I'll pay some seller credits for you. Sometimes buyers will ask for this, say, hey, we're willing to pay your asking price, but we're going to need some help with the closing costs. Can you do that? And that's what we talked about. It's negotiable. All of these things are negotiable. Another thing you might see on the seller, and all these fees are going to show up on your CD, that closing disclosure, or the settlement statement, depending on your type of loan. It's going to be in those settlement statement documents or that closing disclosure document. And we're going to have all these specifically listed, and we'll go through every one. Another thing you may see on the seller side would be agreed repairs. So seller, if you've agreed to pay to fix that door that had termite damage, or you've paid to fix that faucet that wasn't working or whatever. Maybe the heating and air needed maintenance or something like that. Those fees will show up on the settlement statement that we're going to be paying the plumber or the heating and air guy or the carpenter or whoever was out there. Those might be some fees that you would see. Those are also agreed fees, agreed repairs, things the buyer and seller have talked about after that due diligence period. Another thing the seller almost always pays for is the deed preparation. So the deed is the attorney, closing attorney, or seller, if you've got your own attorney, that attorney is going to charge a deed preparation fee, and that's a fee that the seller typically pays for. Also, there'll be an excise tax. They used to be called revenue stamps, and if you look at old deeds from, say, 30, 40 years ago, you'll actually see stamps on that deed where the Register of Deeds stamped the deed. And so we would call those, back then they were called revenue stamps. Today they're called excise taxes. Those two words are still used interchangeably. And all that is a fee that the county charges whenever you sell property. It's universal across the state. It's $2 per $1,000 of sale price. So if you've sold the property for $100,000, you're going to pay $200 in revenue stamps or excise taxes to the county. That'll be on your settlement statement on the seller side. Also, the seller is going to see some prorated taxes on their settlement statement. Now, what that means is we take the taxes for the year, and this is all spelled out in the contract, especially if you use the form contract from the North Carolina Real Estate Commission. It's going to say that your portion of the year that you own the property, so if you own the property from January 1st through June 1st, you're going to pay the taxes for that portion of the year. Now, this is the real property taxes to the county that everybody pays. So the seller pays their portion because they own the property for that portion of the year, and the buyer pays their portion. So their portion so they'll own the property from June 1st all the way through the end of the year, December 31st. So that will show up as a reduction in the amount due to the seller, and it will show up as a credit to the buyer because the buyer is going to pay that tax bill when it comes out in September or August, whenever it comes out. The other thing the seller is going to see, and probably the largest fee on your settlement statement if you've got a real estate agent, is the broker's commission. Typically, that is at the very top. It's a large number, and it's going to come right out of the seller proceeds. Now, in the past, what would happen is the seller would pay the commission for the buyer's agent and the seller's agent. As you guys may know, a settlement has just come down between the National Association of Realtors and the plaintiffs, whoever they were in that case. I can't remember exactly who that was. But they said that sellers are no longer by default to pay the fees for both sides. That's going to be something that's going to be negotiated by real estate agents, negotiated in contracts, and maybe buyers begin to pay some buyer's agent fees for their real estate agent if they want one. We'll just have to see how that plays out, and we're keeping our eye on it, and we'll keep you informed on what we see in the industry as far as how the agents, sellers, and buyers are working through that process. Now, if you're a buyer, so the fees that you're going to see are going to be a little bit different than what the seller sees. Obviously, the things the seller pays for, the buyer doesn't. Oftentimes what we see, especially where there's not a real estate agent involved, the parties can often agree to split the closing costs, and we see that sometimes. It's not as common. Most of the time what we see is this structure that I'm laying out here. So buyer fees, if you're using a bank, you're going to see a lot of bank fees. So there's going to be origination fees. There's going to be one thing we're seeing right now are points. So we're seeing loan points bought, which is a fee that you pay to the bank to reduce your interest rate. Sometimes it makes a lot of sense to pay a little bit of money up front to get that lower rate, and banks will do that for you. So that's something you talk to your lender about. Think about your payment, think about, okay, how long are we going to have this loan, those kind of things to think about whenever you're getting a loan. So those points, origination fee points, there'll be some credit report fees, there'll be some flood certification fees, there'll be an appraisal fee from where the property was appraised. All these fees are charged by the lender, and they add up to, can be a pretty significant amount, especially if you're doing an FHA loan. Some of those HUD fees are fairly large, up in the thousands of dollars. So just don't be surprised when you see those things on your loan documents, and hopefully your lender will have gone over a lot of those before you ever get to closing. If not, when you get to closing, we're going to go through every one of them line by line. Those are the bank fees. The other thing you're going to pay for as a buyer is the title search and closing fee. And that's how your closing attorney gets paid. He does the title search and he sets up the closing, puts all of these documents together and makes sure they all get signed and executed properly, and then also make sure they get to the Register of Deeds and everything's recorded properly. Those are things that attorney gets paid to do. There'll be a title insurance fee. We always recommend get title insurance, and we can talk about what all goes into title insurance in another episode, but it's very important, it's very helpful for you, and it's very inexpensive for the benefit that you get from it. The other thing that you'll be paying for at closing, especially if you're using a lender, is you'll pay for your first year or 6 months of your homeowner's insurance. So that policy will be paid at closing because the lender wants to know that your property that you've just bought is insured. They want to know that if that thing burns down or some horrible accident happens, that they're going to get paid. So that's why we have to keep insurance, and we'll make sure to pay that at closing. You'll see some small things like prepaid interest. Maybe there'll be some inspection fees. Buyer, if you've paid for repairs, there'll be some repair fees on there as well. And also those prorated taxes. Sometimes the buyer has to pay a portion of the prorated taxes. If those tax bills have already come out, we pay those at closing, and the seller pays their portion, buyer pays their portion. When it's all said and done, it's a lot of documents. It's a lot of numbers. It's a lot. It's just a lot. But you're buying a huge investment, the largest investment you'll likely ever buy. And it should be really well detailed and a lot of details and how to know, hey, this is what I'm getting, this is what I'm paying, this is what we're doing. We want to make sure everything is done exactly right. And that's why we want to make sure and hold your hand, go through this process from the very beginning to the end so that you can be confident that, hey, we've got this house and we can rest and be at peace here because we know that everything was done correctly when we bought it. So take your time. Make sure to have a real estate agent. If you don't have a real estate agent, give us a call because we can help. And we want to help you get through this process. Either way, whatever we can do to help, we want to be here every step of the way. So these are the forms. These are the things to expect as you're going through this closing process. If you have any questions, make sure to give us a call, reach out. Make sure to like and subscribe to our YouTube channel, our Facebook page. Keep up with these videos. There's going to be more content like this coming out all the time. Thanks so much for watching, guys, and you guys have a good day.
The information contained in this video and audio recording is general in nature and should not be relied upon in making legal decisions. Every situation is different, and you should consult with your attorney before making any legal decisions.